Oyez, oyez, oyez. The Honorable Superior Court for the Judicial District, Antonio Milford, at Milford, for the transaction of criminal business is now open in session in its place. All persons having cause, action pending, summoned, filed to appear herein shall take due notice thereof and give their attention according to the law. Now, with Judge H. Gordon Hall presiding. Good morning, Your Honor.
Good morning, Marshal.
Court is now in session. You may be seated.
Morning, everyone.
Morning, Your Honor.
Anything that we need to take up before we bring the jury?
No, sir. No, Your Honor.
All right, then could we do that? And you're prepared to proceed, Mr. Riccio?
Yes.
Okay. Morning. Counsel, 6 jurors and 2 alternates?
Yes. Stipulate, Your Honor.
Thank you. You want to call your next witness, Mr. Riccio?
Yes, Your Honor, please. The defense calls Professor Paul Taylor.
Back this way, sir.
Is that right? Okay. Morning, sir.
Please raise your right hand. Do you solemnly swear or solemnly sincerely affirm as the case may be that the evidence, you solemnly swear or solemnly sincerely affirm as the case may be that the evidence you should give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury?
I do.
May you please state your first and last name for the record?
Paul Taylor,
May you please spell out your last name for the record?
Taylor,
May you please state your business address for the record?
3379 West Monmouth Avenue, Englewood, Colorado, 80110.
Thank you, sir.
Please have a seat, sir, and pull up to the microphone so we can hear you.
I may inquire?
You may.
Thank you. Good morning, sir.
Good morning.
From where have you traveled to join us today?
Colorado, Denver, Colorado.
And by whom are you employed?
I'm currently employed by the University of Colorado, Denver.
Right. And for how long have you worked there?
Since 2019, so almost 4 years, 5 years.
And in addition to working at the University of Colorado, do you have another business like in private practice?
I do. I founded the Association of Force Investigators.
All right. And when did you found that?
In 2019.
Okay. Please tell the jury a little bit about, or give them a little bit about your educational history.
Sure. I have a bachelor's degree in criminal justice from the University of Colorado, Denver. I have a master's degree of criminal justice from the University at Albany State University of New York. And I have a PhD in criminal justice from the University at Albany State University of New York.
Now, in what areas do you do consulting work?
Both my research and my consulting work is on police decision-making, human factors, and system safety in the context of police interactions with the public.
Did you have a career as a police officer before you started this work?
I did. I was a police officer for approximately 10 years between the United States Navy, the Riverside County Sheriff's Department, and Boulder, University of Colorado Boulder Police Department.
And from when to when were you a police officer?
I had a break in service, but I started in 2001, and I left policing in 2015.
And just give us a little brief history about the education and the training that you underwent to be a police officer.
Sure. I ended up going to multiple law enforcement academies. There was a Naval Law Enforcement Academy, Riverside County Sheriff's Department Law Enforcement Academy, and then a Colorado Law Enforcement Academy. During that time, I went to quite a bit of in-service training. I was a use of force instructor. I was a training manager for the department. I was a PTO. And so there's a lot of training involved with each one of those things. I was a TASER instructor as well. So each one of those has individual training. I went to training on the analysis of human factors in use of force events, which really started to get me interested in the topic.
And you've trained others in these areas?
Yeah, thousands of law enforcement officers across the United States, specifically on police decision-making and human factors in the context of use of force encounters, use of force investigations. I train on interview techniques for officers involved in use of force cases, and on applying things like perception response time to officers in use of force events.
And where have you taught? Where have you instructed?
All over the United States and internationally. I've trying to think clearly. Colorado, Texas, Colorado, California, Oregon, Washington, Florida, Connecticut, Iowa, Illinois, Ohio. I've taught all over the United States and in Canada.
I know you're a professor. You noted you work at a school. Give us a brief background of your history as a teacher.
Sure. So when I was going to the University of Albany, I started as a teacher there. Most of my teaching is on policing issues in general, so police community relations, introduction to policing, law enforcement leadership, and then I teach classes on research methods specific to criminal justice.
Have you previously testified at a trial?
I have.
And have you testified in both criminal and civil cases?
I have.
And how many times have you previously testified?
I've testified in trial 4 times.
Now, have you been retained by my office for your services and your testimony today?
I was not retained by your office directly. I was asked to come and testify.
Now, I'm going to focus your attention on Trooper Brian North. Did there come a time when you were provided materials to research the situation involving Trooper Brian North?
Was an attorney reached out to me and asked me to review case materials and produce a report.
And do you remember what year that was?
That was in 2001 or 2021.
And describe the materials describe the materials that you were provided to conduct your analysis.
I was provided body camera footage, both what I was told was original body camera footage and enhanced body camera footage. I was provided transcripts, including interview transcripts, and case reports on the event. I was provided dispatch transcripts, and I was provided folders of material on the case.
And can you describe of that material that you were provided, what did you focus your review on?
The attorney who reached out to me had very specific questions for me to look at. And so the focus of my review and my opinion were on those questions that were asked of me.
All right. And what materials were most relevant to your examination?
I looked through all the material that was provided to me. The most relevant material to the specific questions that I was asked was Trooper North's transcript of why he made the decision to use force, and the body camera footage along with the dispatch audio.
What was the task that this attorney in 2021 asked you to do?
I was specifically asked to look at a number of issues. One of the issues was the positioning of the officers at the end of the pursuit, so how they position themselves around the vehicle. Another issue I was asked to look at was the officer's decision specifically to use deadly force, the trooper's decision to use deadly force. The concern that was presented to me was that it was in response to the taser deployment, or it was in response to Mr. Soulemane turning and presenting the knife towards Trooper North.
Now, based upon the questions asked of you in your analysis, did you author a report with your opinions within it?
I did.
And do you remember what year you issued that report?
I do. I submitted the report to the attorney in March of 2021.
Okay. Now, based upon your training and experience and your expertise, did you use that, your training experience and your analysis of these facts to come to certain conclusions?
I used my training, my expertise, my education, and my experience.
All right. And with that, you conducted an analysis, correct?
I did.
So let's talk about certain portions of your report. You stated the first question asked of you by that attorney in 21 dealt with what?
The positioning of the officers around the vehicle.
All right. And what was your observations?
Based on my training and experience, it did not present as a classic felony stop situation. And there are a couple factors that played into that. Probably one of the most important factors was the information that the officers, that the Trooper North specifically and Trooper Jackson as well, were operating off of. The information that they had based on the evidence that I was provided was that a carjacking subject armed with a knife had taken control of the vehicle. There was a pursuit, and at the end of that pursuit, where the pursuit terminated, they had actually come into contact with another vehicle. A classic felony stop type situation would be when the officers kind of maintain distance back by their own vehicles and they call the subject out. Now, there's a couple problems with that in this particular case because there was an occupied vehicle directly in front. One of the primary risks when there's a possibility that a vehicle has been disabled or has come to a stop is that the person inside of the vehicle flees and takes control of another vehicle. Now, some concerns around that are continued pursuit, right? So they'd already been engaged in a pursuit that presents a risk both to the officers and to the public, and we'd like to mitigate that in most circumstances. There's a danger to the individuals inside of that vehicle, and then also there's a crossfire situation. If the officers maintain the classic position in that case, they're pointing their guns not only at the person inside of the vehicle, but at the person inside the stolen vehicle, but also at whoever is inside the vehicle in front of it. And so the positioning of the officers makes sense to me from those considerations. And so my analysis in that case was based purely on my training and my experience as a police officer.
And an additional question regarding felony stop. So your analysis and testimony, at least in this regard, regarding the placement of Trooper North in the front of the car.
Yes, it makes sense to try and prevent the subject from exiting the vehicle and taking over the vehicle that was in front of them, continuing the pursuit and putting the individuals in that vehicle in danger. And it reduces the risk from accidentally shooting into that vehicle should that have been required from a felony stop position.
What was an additional question that was asked of you in your analysis by this attorney in 2021?
Another question was, did Trooper North fire in response to the taser deployment on the opposite side of the vehicle when Trooper Jackson deployed his taser?
based upon your training experience, what was your analysis?
So looking at this, I based my analysis on both the research that I've conducted and the research that's available on perception response times for shooting tasks. And that research, there are now a number of studies out on perception response time for officers in response to a stimulus in their environment. And most of those are laboratory studies. And so in the laboratory studies, so Lewinsky et al. Conducted a study in 2014, and I conducted a study that was published in 2021 on perception response time specifically. And what Lewinsky et al. Found was that when it's a complex stimulus, and by complex, what we're talking about is an officer is aiming their firearm, so they've already started with their firearm drawn, and the researcher has told the officer, when you see this pattern of lights, I want you to start shooting as fast as possible. So that was basically the directions that those individuals got. And when it's a different pattern, any other pattern of lights, we don't want you to shoot. So that was kind of a complex decision environment for those officers, because they're having to distinguish the difference between the two. And so in that research, Lewinsky et al. Found that the fastest time, so he got a range, and he also got an average, found that the fastest time in that environment, when the officer knew what stimulus they were supposed to look for and knew exactly what response to give, the fastest time they saw was around 34/100ths of a second. So that's it's very fast. But what we see is that nobody in that study could fire exactly when the stimulus came on. And again, this is ideal conditions. I ran a similar study, and in my study, we actually primed the officers to believe the subject might be armed. We told them beforehand, they had dispatch information in the study that the subject might be armed. And they were confronted with an individual who had his hands in his pockets and then rapidly produced a firearm or a cell phone from the pocket. And what we saw in that case, when the firearm was presented, the fastest time we saw in that study was 32/100ths of a second. And the averages in both studies were very similar. In the Lewinsky study, it was 56/100ths of a second, about half a second. And in my study, it was 51/100ths of a second, again, about half a second on average. The longest time that we saw in those studies was just over 80/100ths of a second for both studies. And so when we look at that, these were large samples. And so we had, in my study, I had over 300 officers participating, active law enforcement officers participating under ideal conditions when you're not having to discern anything else. Nobody is able to start immediately. And we kind of get a range. It's a range in which we can look at how fast can these decisions be made in the real world. And this actually kind of puts a disadvantage on the officer in the real world because they're processing more information. And we're saying in a laboratory environment, this is the fastest we've ever seen. And in applying that, the taser deployment was 28/100ths of a second prior to Trooper North shooting. And so I can say with a fair amount of certainty that Trooper North was not shooting in response. He did not make a decision to shoot in response to the taser deployment. Now, the follow-up question to that is, could it have been that it was a startle response? That is, there was suddenly a taser deployment and Trooper North had a startle response. Well, behaviorally, there's a couple of things that tell me that's not very likely. Typically with a startle response, and I have looked at shootings in which officers have had startle responses, an unanticipated discharge, typically there's a bodily reaction to that. And typically you only get 1 or 2 rounds with that. So an officer's firing very fast. If Trooper North had a starter response and then tried to follow up with additional shots just because that's what he did, we would see a break. We would see a break between those 1 or 2 shots and the follow-up shots because there would be another decision in there. And so we would see a decision time. We don't see a break. When we look at all 7 shots, the average time is just over 20 1/100ths of a second. And that is indicative of pulling the trigger as fast as possible. The Lewinsky study examined that and saw that. And so those are the studies that I relied on to look at whether or not it was could have been in response to the taser deployment. And my opinion is that it could not have been.
Did you analyze the length of time it took from the first shot being fired by Trooper North to the last shot being fired? And how long was it?
I did. For the exact number, I'd have to refer to the report, but it was 1.4 some seconds, so almost 1.5 seconds.
One additional question regarding perception response times. Can you give the jury, let's say, one additional example, sort of like a real world example of perception response times and how it applies?
Absolutely. And in fact, perception response times have been used in crash reconstruction for a long period of time. What we come to understand is it takes a driver time to perceive a change in their environment and actually start to activate the mechanics of stopping or steering. And so understanding that, and there's Dr. Green, I'm blanking on his first name right now, has done a significant amount of research and has compiled the data on how to use perception response time for crash reconstruction. The same thing applies for officers making the decision to shoot. And so when an officer sees a stimulus and has decided to pull the trigger, the stimulus that drives forward that response never aligns directly with when the bullet is actually fired. There's always a break, and that's even under perfect conditions. We can, again, in a laboratory environment where we tell them what stimulus to look at and we tell them what to do in response to that. I've never, and I've done quite a bit of research on this at this point, I've never seen an officer start at the start signal. There's always a delay, and if there's a decision in there, that delay consistently produces about a half a second delay between the decision and the first shot that's fired.
Returning to the questions asked of you to then place conclusions in your report, what was an additional question that was asked of you?
An additional question was, did Trooper North fire in response to Mr. Soulemane turning towards Trooper North with the knife at the window? My conclusion on that is that he did not and could not have fired in response to the knife coming towards him at the window. The movement from a position where Mr. Soulemane was looking in the direction of Trooper Jackson and Officer Rappa on the other side of the vehicle to the time it was pointing towards Trooper North and the first round was fired almost simultaneous with the presentation of the knife was around 20/100ths of a second. And again, the fastest time we've seen in laboratory environments is 32/100ths of a second. And that's the fastest. The average is half a second. Again, the fastest in ideal circumstances was 32/100ths of a second between the two studies that I referred to in this report. And the average time was around half a second. And so when we look at what was occurring at around half a second, we can use the range, in fact, which is probably a better thing to do, 32/100ths of a second to 87/100ths of a second, I believe. If we look at that range, there are a few things that are happening within that range. First of all, Trooper Jackson is rapidly moving towards the window that has been broken out. Secondly, Officer Rappa has first started to draw his firearm in response, I assume, to something he saw inside the vehicle, and then reholsters, but he is ducking down at the same time and attempting to reach towards the door. And so the things that Trooper North described as occurring when he made the decision to pull the trigger are in fact supported by the perception response times that we see in laboratory studies.
Now, you said on multiple occasions in laboratory studies, which are controlled environments, correct?
They are. That's the whole point. They're very highly controlled.
And you testified that you viewed video evidence of this incident, correct?
I did. Yes, sir.
Is it fair to say that the scene on off exit 43 could that be considered a controlled environment?
No, it would be the opposite of a controlled environment.
Let me ask again, any additional questions that were asked of you in 2021 to then place in your report?
There were some follow-up questions. One of them is a little outside of my area of expertise. I was asked about body-worn cameras and the difference between what an officer sees and what body-worn camera footage presents. What I can say from a layman's perspective is that body-worn, and having reviewed a lot of cases, is that body-worn camera footage is a different perspective and oftentimes has things like light enhancing capabilities. So what the camera is viewing is different from what an officer is viewing in the moment. One other issue that I was asked to weigh in on was crossfire type situation with other officers. I weighed in on that briefly. One of the things that happened during the encounter is that as kind of the dynamics inside of the vehicle and outside of the vehicle were occurring, some other officers were moving up on the passenger side of Mr. Soulemane's vehicle. As Trooper North was firing into the vehicle, they moved into a position that may have presented a crossfire situation. There are a couple factors that come into play. Once an officer's focus of attention has kind of been captured by the threat, and this is very common, there's good research on this. In fact, about 80% of officers report experiencing some type of perceptual distortion. And those are the ones that realize it after the fact. In the research, I would estimate that it's probably higher than that. And so things like tunnel vision and auditory exclusion are very, very common during these encounters. And the example I like to use with this is driving. When we're driving along, we have a lot of skill at driving. We have a lot of experience at driving. Most of us can do it without a lot of thought process, without a lot of attentional focus. We can also have a conversation with somebody who's right next to us. And that's something that under ideal circumstances, neither one takes a lot of attentional demand. But if suddenly a deer runs out in front of you as you're driving, are you able to carry that conversation on? And most people are not able to do that at the same time. Their focus of attention goes to avoiding the deer. Most officers have never been involved in a shooting when they get into their first shooting. So it's a novel event. They have had training, but typically a shooting is a novel event. And there's great research in the victimology realm on threat when a threat is presented. Oftentimes victims aren't even able to describe what the subject looked like. And we know that after the fact, they're usually not very reliable witnesses on identifying a subject because they've seen it, they were threat focused. The same thing happens to officers. Officers are human beings in these incidents, and their attentional capacity is taken up. And so when we're talking about crossfire situations, it's indicative on all officers, especially officers coming into a new environment, not to move themselves into a crossfire situation. And so I would put the onus on the crossfire situation on the officers who are moving up on the passenger side of the vehicle.
Did your analysis involve withdrawn? Is it fair to say your analysis involved the event at the car with Trooper North, correct?
Objection leading.
Rephrase,
I'll
please.
What other evidence was relevant in your analysis?
Based on the request from the attorney, my analysis was very, very focused. It was really unlike any other kind of expert report that I've written. The attorney had very specific requests and kept coming back with different requests. Never asked me to change my report, but did ask for different information as we went along. But the primary information that I relied on was around the actual decision to fire itself.
And ultimately, in your report, you came to a conclusion it relates to perception, Trooper North's perception, correct?
As far as perception response times?
Correct.
Yes, my primary analysis on the decision to fire. So when I look at a case like this, and I have an officer's statement as to why they fired, I use a research method to examine that. So I treat that as a hypothesis, and I look at whether or not both the empirical evidence and the relevant research supports or does not support that statement. And in some cases, the evidence and the available science does not support what the officer has said. In this case, the officer's statement was that he believed that officers were attempting to enter the vehicle on the other side. He was concerned that Mr. Soulemane had a knife and could injure or kill those officers, and he made the decision to fire. When we look at what was happening when he would have had to make the decision to fire the first round,
I think he's going to comment on Mr. North's reasonable beliefs in this regard, and I don't believe that's appropriate evidence for this witness to give.
Okay, can you withdraw that question?
This is a narrative sort of answer that kind of is not pursuant to any question Mr. Ricky has asked.
Okay, could you withdraw that question and go step by step?
Sure.
Thank you.
So you came to a conclusion regarding Trooper North vis-a-vis perception response time. And again, what was that conclusion, simply put?
Simply put, Trooper North's statement aligns with what I understand about perception response time from the relevant research, and is supported both by the empirical evidence and the relevant research.
Can I have a moment, Your Honor?
Yes.
Just a couple more questions, sir.
Yes, sir.
These opinions that you've given and the analysis that you've done, are these based upon a reasonable degree of professional certainty?
Yes, sir.
And this is based upon your training and your experience
In my own research, yes, sir.
in the fields that you've testified to?
Yes, sir.
Thank you, sir. No other questions.
Thank you.
Cross-examination, Mr. Devlin?
Yes, thank you, sir. Good morning.
Good morning, sir.
So you indicated that you have a business called Association of Force Investigators,
Yes, sir.
and your partner in that business is James Bordon, the witness we're going to hear right after you.
That's not correct.
Well, didn't you start the business approximately 2010?
In 2010?
Yes.
No, sir.
Let me check this.
No problem. The Association of Force Investigators was started in 2019.
Okay. So as Mr. Bordon put in his CV, that in July of 2020, I co-founded the Association of Force Investigators with Dr. Paul Taylor. That'd be incorrect?
He played a consulting role, but he's never been on any business. Any business.
He was founded. Is that incorrect?
He played a supporting role. We certainly had communications about it.
In your review of the material for your analysis here, were you ever directed to, or did you ever review Trooper North's statements, oral statements at the scene to his sergeant or to another trooper?
I was not provided that, though I've learned of it recently.
Okay. And you were aware, sir, were you not, that Trooper North prepared the statement you referred to after he reviewed the body-worn camera footage as well as the dash camera footage that was generated in this case, correct?
Not specifically, but it would appear that way. Yes, sir.
Okay. And you have said publicly that practice of giving a statement after you review body-worn camera is an inferior way to have an officer relate what happened, correct?
It is. The preference would be that an officer not review body-worn camera footage from a human factors standpoint. However, it is very common practice for officers to review their body-worn camera footage, and in some places, it's even policy.
Well, you've said publicly that it contaminates critical evidence by doing it that way, correct?
Absolutely. Memory is tainted by reviewing body-worn camera footage.
Now, so you mentioned this idea of a second carjack, and you acknowledge in your report that none of the officers mentioned any consideration of that, correct?
That's correct.
And in fact, no witness in this case, and we've heard from every officer that was there, have mentioned in their wildest imagination were they concerned about a second carjack. So did you just introduce that on your own?
As far as being concerned about a carjacking, their positioning makes sense to me from the perspective of where the vehicle ended up and a classic felony stop. So based on my training experience, their positioning absolutely makes sense.
But none of them said they were concerned about a carjacking.
That is absolutely true.
Okay. So you would acknowledge, sir, that absent that concern about a carjacking, which no one said there was a concern about that, running up to the car in the manner that they did was highly dangerous for those officers, wasn't it?
It's dangerous regardless of their positioning. They're on an active roadway. I would argue that the crossfire situation is also a primary consideration, that pointing your firearm at another vehicle with other people inside of it is very hazardous.
Well, are you familiar with this book, sir, The Tactical Edge by Mr. Charles Remsburg?
I have seen that book.
Isn't this sort of a classic text? It's old text.
It is one of the first law enforcement books I read when I became an officer.
Right.
Yes, sir.
And is this maybe there's other authorities, more recent authorities, but is this recognized authority on police tactics?
No, I would argue it's not, and I have issues with what's been produced in that book. It was a fundamental book, but I have strong disagreements with the information contained in that book.
Okay, when he's talking about this idea of high risk stops,
Yes, sir.
and would you characterize this stop as a high risk stop?
Yes, sir.
Would you agree with this statement? One of the few absolutes in officer survival applies to high risk stops: never, ever approach an occupied vehicle.
I would take issue with that statement.
Okay, well, would you be surprised if the Connecticut State Police in their training module said exactly the same thing?
I would not be surprised. The model for a high risk stop in training is that officers set up the safest possible scenario.
Now, you reviewed the body-worn camera and the dash cameras in this matter, as you indicated. Some of them.
I reviewed the material that was provided to me.
Right. And in fact, no officer was ever attempting to enter that vehicle at any point. Is that correct?
I don't believe that's the case.
Okay. Well, you're saying that they were entering the vehicle?
No, I'm saying that officers were attempting to enter the vehicle on multiple occasions.
Now, when you say enter the vehicle, you mean open the passenger door?
I mean multiple attempts to open the passenger door and breaking out the window.
Correct. Was anybody crawling through that window as depicted in those camera coverages?
Not that I could see, no, sir.
But that's okay, not that you can see. Now, you talk about this concept of tunnel vision. And tunnel vision is this notion that an officer's attention is pretty much 100% directed toward the threat, correct?
It's an external narrow focus of attention, and it's visual. So external narrow focus of attention can occur through any of the senses. But in this case, typically when people talk about tunnel vision, they're talking about sight vision.
Tunnel vision, you're talking about vision?
Typically, yes, sir.
And so you indicated that this notion that other officers might be at risk for firing into that vehicle was sort of on them because North had tunnel vision into the car.
No, I'm saying that as approaching officers running up on a vehicle, when you see other officers pointing their firearm, we want a cover officer, which is the role that Trooper North was playing, to keep their focus of attention on making the best decision possible in that case. And so other officers, it's incumbent on them not to place themselves into crossfire situations.
You indicated in your report that you thought it was likely, based on the tunnel vision, that North was unaware of those officers on the other side.
Well, I think what I said is it's altogether plausible that he was unaware of those officers approaching.
Okay. And if he's unaware of the officers approaching, he'd be unaware of their heads bobbing up and down next to that car, correct?
Of the other officers?
Yeah, on the passenger side.
Yes.
We're aware, sir, that just before Trooper North fired, one of the other officers yelled out, "He's reaching, he's reaching." Do you recall that?
Not specifically.
Okay. And were you provided with Officer Rappa's statement that he did not intend to enter the vehicle when he decided to break out the window?
I believe that was a supplemental report. I believe his original report was that he intended to pull the individual out of the vehicle.
And he supplemented that by saying he broke the window to open lines of communication or maybe use some less lethal force, correct?
I believe that was in his supplemental report.
Did you ever consider the possibility that in connection with North's statement, as you indicated, someone was entering the vehicle through the window, that Trooper North could have just looked to see if that was happening? Did you ever consider that?
At which point, sir?
At the moment before he fired.
Taking your focus of attention off of the individual the moment before you fired would mean that he has to refocus, and that's going to take time, and it's going to take time for him to come back. In the analogy that I used of driving and a deer running out in front, when your focus of attention is captured by a potential threat, the tendency, it's happening at a subconscious level, you're not going to turn away from that threat. It's not human nature, and it's not what people typically do in those situations. Looking at empirical cases from across the country, it's very rare that an officer is going to turn away their focus of attention from that threat.
Well, he claims he turned away to see their heads bobbing up and down on the other side of the car.
I think we're talking about two time frames. And one of the challenges we run in when we're looking at an officer's statement after the fact is that we have a chaotic event that's happening and there are multiple things happening at the same time. And the officer has to use language to describe that. And when an officer is using language to describe that, it becomes much more linear and it starts to make more sense than the actual event itself. Prior to Mr. Soulemane the window being broken out and Mr. Soulemane starting to wave the knife around, there was...
You saw Soulemane waving the knife around? Is that your testimony?
Based on the statement.
No, based on what you saw.
No, not based on what I saw. That's not...
Wait.
Yes, sir.
You've made a statement, he's waving the knife around.
Based on the statement that Trooper North gave.
Well, you checked that out, right? You looked at the body-worn cameras that would show this.
Not everything is visible on the body-worn camera footage.
Okay, what was visible on the body-worn camera does not show him waving that knife around, correct?
I'm basic. The knife does swing towards Trooper North. There is movement of the knife visible inside of the vehicle.
The difference between movement of a knife for maybe an inch and swinging a knife around, those are two different concepts. Wouldn't you agree?
I'm basing it solely on the officer's statement.
Wait a minute, you looked at this body-worn camera material.
Yes, sir.
Was it swinging around as you said or not?
Not as I said.
All right, not as you
that's
said.
That's not my statement. It was Trooper North's statement. As
I'm asking you for your observation of this body-worn camera. Was it swinging around or not?
Sir, I can't see.
What do you mean? You can't answer that?
No, I can't answer that based on the vision.
That's your answer. Thanks.
Yes, sir.
Just a moment, please.
Yes, sir.
And as you indicated, you never reviewed North's statements to his superiors or his co-workers, co-police officers at the scene itself, correct?
I was not provided that.
Thank you. No further questions, Your Honor.
Anything, Mr. Riccio?
Briefly, Your Honor, thank you. Professor Taylor, what relevance, if any, exists regarding post-incident statements?
Post-incident statements immediately after the event tend to be incomplete. And so my analysis is focused on the trooper's description of why he did what it is that he did. And so, again, I haven't reviewed that evidence, so I don't want to speak directly to it. But oftentimes, statements are made immediately after the fact. And it certainly should be considered in the totality of the circumstances. But oftentimes, those statements are incomplete and very brief.
And you provided testimony today regarding this theory of perception response. In this case, from what point to what point was the relevant time frame that you conducted your analysis? That is to say, regarding this incident, from what moment did it start? From what moment did it end?
My personal analysis of the case. So there was information that the trooper brought with them. So that's relevant, an understanding of how they're viewing the behavior and what's occurring in front of them. And so the dispatch information and the pursuit leading up to that is important information to understand why we're responding the way that we are. But then my actual analysis is from the time that Trooper North exits his vehicle to the last shots that are fired in that particular case.
So does your analysis regarding perception response deal with post-arrest statements, post-incident statements?
Not specifically. If the officer is indicating specifically why they fired, there may be some relevance there. But again, those statements are going to be incomplete. And I'm interested in the totality of the officer's statement. What were they seeing, and what was the reason they made the decision to start shooting?
Now, you were just asked some questions about the activity in the car regarding Mr. Soulemane. Can you, just so that there's no confusion, what did you observe?
Specifically, there was movement inside the car. And I'm relying on Trooper North's statement describing what was happening as far as describing the knife waving around. There's movement inside of the car, and there's more than a few inches of movement. The knife clearly comes at the final point all the way across Mr. Soulemane's chest towards the window in which Officer or Trooper North is standing outside of.
And through your review of the video evidence, what did you observe regarding movement in the opposite direction?
So one of the kind of key things that I looked at is kind of the behavior of Trooper Jackson and Officer Rapa. And there are two elements to that made me believe that there was a threat in their direction. The first was Trooper Jackson's, Officer Rapa reaching down towards his sidearm and starting to pull his sidearm out. That made me believe that, in fact, he felt a threat coming in his direction, at least at some point during that interaction. The other aspect was in several of the frames, you can see the laser of the taser that Officer Jackson is holding, and it's directly on the knife hand of Mr. Soulemane. Oftentimes in officer-involved shootings, officers are so focused on the threat that they will actually shoot at the hand. And that tells me that Trooper Jackson was likely very focused on that hand as well. It presented something that he was focused on. You wouldn't deploy a taser towards somebody's hand. And so that really kind of tells me that he was focused on that hand as well. And so that tells me on the other side of the vehicle, there was at least on Officer Rapa's part some concern about something that was going on inside the vehicle, and it appears that Trooper Jackson was also focused on that knife.
The information, the materials you provided included a statement from or information regarding Officer Rapa. You were asked questions about that, correct?
That's correct.
And what was the initial statement that he made regarding his actions?
His initial statement was that he intended to, and I'm paraphrasing here, he intended to pull Mr. Soulemane out of the vehicle. That was his intention.
One moment, please, Your Honor.
Yes, sir.
One other series of questions, sir, and then I'll be done. Attorney Devlin asked you some questions about Trooper North's perception of other officers. The phrase other officers was used. And just for clarity purposes, can you please describe what you meant by other officers? And maybe if I can ask it differently, who did Trooper North, in your opinion, see, and who, I guess, did he not see?
So,
Your Honor, he doesn't know who North saw or didn't see. I object to that.
I'll rephrase.
Yeah.
I'll rephrase the question. Through your analysis, there were questions asked you about the observations of other officers. What were those?
No, there were questions asked about tunnel vision and its effect. That was a question. I object to the form of that question.
The question on Cross had to do with tunnel vision, I think, and focus of attention fairly. So could you focus your attention on that, please?
Michelle, relating to tunnel vision and who could have been seen. Please explain your response regarding tunnel vision again.
yeah, there's kind of two segments to this. There's the initial segment as Trooper North and Trooper Jackson kind of set up on both sides of the vehicle. At that point, there's some communication going on. Trooper North tells his partner, Trooper Jackson, to go to taser. And it appears, and based on the statements of the officers, that Mr. Soulemane was not moving around initially. Based on Trooper North's statement, that changed, and there's the presentation of the knife that he observed inside the vehicle. And that at that point, there's going to be a change. So observing what's going on the other side of the vehicle as things are kind of static and you're trying to make a decision about what to do. And then the presentation of the threat. And again, it's like driving along. You can have that conversation with somebody else and suddenly a deer runs out in front of you. All of your attentional capacity is taken up with avoiding that collision in that case. And so it would be very similar for Trooper North. We have the initial portion. He's able to, based on his statement, observe some things that are happening across the vehicle, and then there's the actual presentation of the knife, and that's going to capture an individual's attention.
And sir, finally, Attorney Devlin had presented a text from some time in the past. Is it fair that scholars can disagree about things?
Well, yes, sir. Scholars disagree all the time.
All right, thank you very much.
Anything brief, Mr.?
Yes, a few questions. Thank you, Your Honor. Officer Rapper's statement that his intention was to get Soulemane out of the car. Remember those questions Attorney Riccio asked you about that?
I'm sorry, Officer Rappa?
His statement that he was trying to get Soulemane, his intention was to get him out of the car?
Yes, sir.
Okay. And his efforts in that regard were direct to opening the passenger door, correct?
And also breaking out the window.
And breaking out the window, not crawling through the window.
I did not observe him crawling through the window.
And in fact, throughout this entire event, Rappa and Jackson were always outside the passenger part of the car, correct? Standing on the pavement.
The available evidence would show that they both made attempts to open the door and both made it. And Officer Rappa does appear to be reaching around the where the window was. But yes, neither of them actually entered the vehicle.
This taser deployment that Officer Jackson was trying to effectuate, he's trying to deploy a taser to a person seated in an automobile, leaning back through the window of the car, correct?
That's correct.
That's a pretty tight shot. Would you agree with me on that?
Absolutely.
You mentioned the time between Trooper North exiting the vehicle and the commencement of shots. Do you remember how long that was? How much time elapsed between him exiting the vehicle and commencing firing?
Not specifically, no, sir.
Would you disagree with me if I said it was 35 seconds?
I have nothing to compare it to, sir.
Okay.
I would have to look at it.
All right, thank you. I have nothing further, Your Honor. Thank you.
All right.
Nothing further, thank you.
All right, thank you, sir.
Thank you, Your Honor.
Excuse.
May we approach for just a moment?
Sure.
Thank you.
Recess before the next witness. So 15 minutes, 20 after 11. We'll recess.
All right.
Peters? Wow, that's good.
Court is again in session. You may be seated. Good morning, again, Your Honor.
Good morning, Marshall. Morning again, everyone. Anything before the jury comes back?
I know, Your Honor.
No, Your Honor.
Okay, can we get our jury?
Right up this way, sir, please.
The jury. Six jurors and two alternates, gentlemen?
Yes, sir. I stipulate, Your Honor. Thank you. Your Honor, the defense calls James Bordon to the stand.
Over here, sir.
Sir, may please raise your right hand. You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, sir.
May you please state your first and last name for the record?
James Bordon,
May you please spell out your last name for the record?
B-O-R-D-E-N,
May you please state your business address for the record?
3484 East Saddle Avenue, Las Vegas, Nevada, 89121.
Thank you, sir.
Thank you.
Please be seated, sir, and pull yourself up to the microphone so we can hear you.
Yes, Your Honor.
Thank you. You may inquire, Mr. Riccio.
Thank you, Your Honor. Good morning, Mr. Bordon. Still morning. From your address, have you come to us from Las Vegas, Nevada?
That's correct.
Okay. And how are you employed currently?
Currently, I am a business owner. I founded, and am employed with my company, Critical Incident Review.
Okay. And for how long has that business been in existence?
So I started the LLC, I believe, in 2013 and started consulting under my own umbrella probably around 2018, 2019.
And what type of consulting work is done through your business?
So primarily Critical Incident Review is a training company, law enforcement-based training company, where my focus is on the investigative process, three core classes: enhanced force investigations, forensic video review and analysis, and then a leadership contingent where we talk about the perspective of use of force analysis as it's received by executive command. And then the consulting aspect of it is primarily in use of force analysis, where there's video component as part of that analysis, and looking at the overall investigative process and analyzing behavior and decision-making processes as those relate to policy, police training, and all of the evidence in the case.
Please explain to the jury a little bit about your educational history.
So most of my education is specialized education in the field of human factors, human performance, as it relates to the police practice. So my education, I'm certified heavily in analyzing force through the application of human factors, which is very broad, but it talks mostly about perception, cognition, decision-making, motor learning, things of that associate with a human factor, but related directly to the law enforcement field. The training that I had ancillary to that was to get my certificates as a police officer. I had a basic, intermediate, and advanced certificate. So the education that went along with that, mostly police related, some of it psychology related. To get the advanced certificate, I had to have X number of college credits. I exceeded that. I think I had a total of 45 or 48 college credits to get my advanced certificate from the department that I eventually retired from in 2018.
It sounds though you were a police officer at one point. Can you explain your history as a police officer?
Sure. I was hired in 96. I actually started in 1997, which seems like a lifetime ago. I was an officer until I retired in 2018. I retired as a sergeant. My retirement position when I left the department was the sergeant over the training division. In the training division also existed the unit that I created, which was the use of force training and analysis unit for that department. It was a large department, approximately 500 officers. And I was also the sergeant over the police employee assistance program, that all three were very closely associated. And in that position, the core of my, responsibilities in the training division were focused on use of force. Although I was the sergeant over the entire training division, my subject matter expertise was use of force. So citizens academies, the new officer academy, anything where there was any training that had to do with use of force, I was involved in directly or responsible for the lesson plans.
How many, where have you done this training and how many people have you trained?
We're moving away from the police department, I believe, Counsel.
Yeah.
So the training that I provide now, I've been contracted by on the training side of it, I've been contracted by the California Department of Justice, the Army Criminal Investigations Division, Army CID. I've conducted all of their training and for their leadership as well, regarding enhanced force investigations and forensic video review and examination. The Texas Rangers, I've provided their in-service training. I've been contracted with them to provide training for most of Texas DPS. I've been contracted by Arizona DPS to the tune of about 2,500 to 3,000 officers, and multiple smaller jurisdictions that self-register into my courses that are held across the country. And I've had these classes from Anchorage to Maine. And speaking wise, lecturing, I lecture to entities like the Defense Research Institute, which is primarily attorneys and insurance holders. I've lectured at the CalFIA, the California Force Instructors Association, and I've done a lot of lecturing in the state of Connecticut at the use of force summits here over the years.
Have you been involved in prior cases? Have you been utilized in prior cases to research and analyze use of force?
I have hundreds.
And have you provided testimony throughout? Withdrawn. Have you testified consistent with that?
Yes, I've testified in relation to my opinions on those cases.
And civil or criminal or both?
Both civil, criminal, both federal level civil, state level civil, criminal trials, arbitrations, anything where there's the need for an expert's opinion regarding the behavior of an officer involved in a critical incident.
And how many times did you say you testified previously?
Deposition, probably 60 to 70 times. In a courtroom setting, in trial, probably I think this makes 26 times. And then a couple times in arbitration, state level arbitrations that aren't necessarily a courtroom setting.
To get back to your private practice, sir, again, can you just briefly describe the nature of your private practice?
Again, it's rooted in investigations training, the evaluation of video, the evaluation and assessment of critical force incidents where police officers are involved, both on the lecture side and on the consulting side regarding opinions and reports.
And when was your first involvement in the matter involving Trooper Brian North?
I think the report was done September of 21. So it was probably 6 to 8 months prior to that.
Right.
And I don't have, it was a long time ago, so I don't have an exact date on when I was retained on that case.
And you mentioned the word retained. Sir, have you been retained by Trooper North for your testimony today?
I have not.
And you've come from Las Vegas to provide testimony here today, correct?
I have.
So getting back to your involvement, what were you provided to conduct a study and analysis in this case?
A standard the provisions were standard. The case file, video, photographs, diagrams, statement-based evidence, anything that would have reflected physical or forensic evidence from the scene, radio recordings, transcripts if they were available in the case. So basically as comprehensive of a case file as I could get. And at the point that I received this case, I assumed that I had received everything that was available at that time.
And what was the request made of you? Said differently, what were you asked to focus on, and what were you asked to provide opinions on?
So when I got this case, the request of me was to look at the use of force regarding Officer North and conduct an assessment and an evaluation of that occurrence and give opinions on the decision-making process, the assessment that was occurring during that time. And I don't have a copy of the report available. Is there a way for me to look at that? Because that has a summary of my opinions on that case.
And I will ask questions relative to your report. I do have a report, but is it fair to say that your analysis found it's withdrawn? Did you write a report consistent with your findings?
Absolutely, yes.
And is it a multi-page document?
It is.
And once you did your analysis, you sent it to back to the requesting party?
That's correct.
All right. And getting back to the questions asked, what specifically were you asked to do?
So the evaluation of this case at the time that I evaluated the case, there were no pending charges on the case. So I was just asked to evaluate the behavior based on my experiences and my expertise in police training, in police application of tactics, decision-making processes, and in this case, some of the human factors components, decision-making times, what windows of time were available for the officer. Some look at the interaction because there's some shared knowledge there, shared cognition, to use the big fancy term. It's just what the officers knew, pre-existing information moving into that scenario, and then focusing primarily on the decisions made by Trooper North in that case, considering all of the factors.
So what, sir, I'm going to do now is bring you through those issues and have you provide your opinions. So again, from your recollection, what was one of the first questions that were asked of you?
Was the force excessive, to be, frank about it? And I'm very cautious, and I'll put this out. I'm very cautious about using terminology about the ultimate issue, right? And I can only tell you what the answers to the questions are, but just so you understand, I'm very cautious about that because I understand your role as a jury.
So what was your analysis regarding this first issue that you just spoke of?
That the use of force in this case was appropriate based on a foundation of all.
Objection.
Sustained.
What information did you?
That is the ultimate. I object to that question.
It would be stricken also if any of it was responded to, ma'am. Thank you.
We'll just back up a bit. You had testified about certain factors or certain things that you were looking at, putting aside use of force for a moment. Explain some of those other factors that you were asked to look at. And more specifically, what were some of the questions that were asked of you by the requesting party for you to analyze?
Searching my memory, it boils down to the decision-making process. And so I have to give you some background on how I conduct my analysis. And counsel, is that okay to do that?
Please explain how you conduct an analysis such as this.
Okay. So to conduct an analysis like this, I have to have an anchor. And the anchor in this case is what's called the objective standard. And that has been put in forth by Supreme Court case law decision. When I look at that, there's a 3-part test that goes along with that. What's the severity of the crime? Was the individual an imminent threat? And was there a continued resistance or attempt to avoid arrest or detention? That's the first three-part test. In this case, because I'm in Connecticut, I had to consider the statutory component of that, the Connecticut General, it's CGS, the Connecticut General, anyways, it doesn't matter. I think it's 53A22C is the number. I can remember that. I'm a numbers guy. So that anchor itself has a two-part test that the officer has to reasonably believe that there's a threat, an imminent threat of substantial bodily harm or death in a deadly force case. And the second part of that test is it an objectively reasonable belief, not use of force, not to be to contaminate the ultimate issue, is the belief that there's a need and a threat existing and a need to address that threat, is it objectively reasonable based on all of the evidence that exists in this case? So my anchor is now two-part. I then have a third anchor that I tie into policy for the department and the use of force matrix that's a part of the decision training and the training process of the officers regarding how their use of force is going to be judged in hindsight, because all of these are hindsight analytical tools, if that makes sense. Everything is known after the event happens, the information is known, and now we do an assessment. So that three-part component is how I conduct an analysis on these cases. And each part of that, I have to do a triangulation between what the officer stated was an articulated belief in that moment. Was there evidence to substantiate that belief? The officer stated that they felt there was a threat because of X, Y, and Z. All right, does X, Y, and Z exist in the form of evidence, video evidence, statement evidence, physical or forensic evidence from the scene? And if that stuff exists, is it now an objectively reasonable belief based on all of the information that we've triangulated? And in this case, it was. So my opinion is that all of the evidence in the case—
Objection, Your Honor. Objection, Your Honor.
I'll ask a question.
I'd ask that answer to be stricken, the last part of the answer.
Yes, ma'am, please strike that.
Sir, what I'd like for you to do is just take a moment with, again, not speaking on the ultimate issue. In your assessment and analysis of this case, did you analyze certain facts relative to the case?
Yes.
Okay. Please tell the jury what specific facts you thought were relevant to your assessment and analysis in this matter.
The primary thing that I look at going into it is what was the pre-existing information. So the first prong of the calculus of the standard for objective reasonableness is what was the severity of the crime at issue. So I looked at the facts that the officers knew at the time of the contact. In this particular case, it was a carjacking with a weapon, threat of force, a very long pursuit, and a violent end to that pursuit, not of the driver's volition, but because of a collision. So the pursuit ended the way that it ended outside of a decision to pull over or to acquiesce to police presence. So that's the pre-existing contextual information that I'm looking at. I'm looking at the task environment that the officers are now making contact in. I then looked at the articulated dangers that the officers believed were occurring or could occur. And remember that hindsight's 20/20. So we are disallowed by the standard from the Supreme Court decision to make decisions that say should have, would have, or could have, because in the moment the officers did not have a crystal ball and they couldn't predict the outcome. And that's a very important component of this entire analysis, as it is with every analysis. So at that point, is the foundation there for the decision-making process clearly visible in the evidence? And the pre-existing information is where I start. The information that I gleaned in statements is next, what was said to have happened. And then what do we see in the video, in the evidence? The claim was that there was a knife. There's a knife in evidence. We see a knife in the video. So there's a triangulation of information that say that, yes, it's reasonable to believe that all of that is foundational.
What is reasonable to believe? I object to that phraseology. That's ultimate issue for the jury.
I think we need to just ask more questions. That will be stricken, and if you could take the witness through what you want to cover.
Yes. So you were just discussing issues relating to pre-existing information, correct? And that's one of the issues or one of the things you looked at, correct?
Sure.
Did you look at officer assessment?
Yes.
Okay. Please bring us through your analysis of officer assessment.
I can never make a claim that I know what the officers assessed. All I can do is look at the evidence. And so I can't assume anything. In this case, we see the officer's behavior, and that goes along with the assessment that, with all the things I've talked about, which I don't want to keep beating that horse to death, that all of that did exist. And the assessment of that and the calculus in the objective standard, I'm going to use those words to mince terms. I don't want to mince terms. Everything was foundational, and what occurred in those moments was exactly what the officers portrayed them to be. It was a violent encounter. There was a weapon in play. All of those things existed in my analysis of the evidence when I looked at all three triangulation points.
Could you also speak on threat cues and as it relates to Trooper North in this matter?
Sure. So in threat cues is a part of what we have as pre-existing information, what the officers were dealing with. And at the moment that the officers make contact, and I'm certain that you've all seen the video probably 100 times, we have officers that arrive and they're making contact. And one of the points that come up in some of these analysis is time, distance, speed, and motion. Things like a tactical pause. And in an environment that is tense, rapidly evolving, and dangerous, as this one was, which is clearly visible in the video, the officers do not immediately move to contact. That is considered a tactical pause. And I need you to understand that terminology, that tactical pause is them approaching that vehicle and then assessing. And that assessment is happening constantly throughout this environment, to the point that there's no interaction between any officer, with the exception of officers deeming this a deadly threat, because the officers are responding with weapons out. And that's visible in the video as well. That's not an assumption. Weapons are out. Officers are now assessing the danger that is possible or probable in this environment, meaning that this has been a pursuit with someone who has failed to yield, and there's a probability that if they don't remove that threat, that threat's going to continue. And that's called police work. So that whole assessment process is happening. There's no overt use of force until they attempt to move to contact. So the threat cue would be the movement inside of the vehicle, where the subject appeared to be unconscious for a moment. And as entry is being made to move to contact, a threat cue would be the subject.
Objection, Your Honor. There's no evidence the entry was made here at all. I don't know. I have no idea where this narrative is coming from. I object to it. Move to strike.
Yeah, I just, I'm going to sustain the objection. Sustain.
Mr. Bordon, relating to threat cues, again, what overall are you trying to accomplish in trying to in this particular area? Like, where does your analysis go? What are you trying to arrive at?
Simply that decisions made in a scenario like this are based on the behavior of the suspect. That's it. That's the threat cue. So the suspect is a behavior. The officers assess a behavior, and then they make a decision based on that behavior. That behavior is considered a threat cue.
And when you speak of the behavior of the suspects, you're talking about the actions of the suspect?
Correct. The actions, in this case, inside of the vehicle.
Okay. And just so the jury is clear, you use the terminology move to contact. Can you explain a little bit of what that means?
Sure. It's simply exactly what it's stated, that there's a perceived threat, and officers, in an attempt to reach the goal of de-escalation, will move to contact and subvert that particular threatening component. In this case, there's a driver behind the wheel of a car that was just in pursuit, and the move to contact component is simply the officers breaking the window, or the things that you've seen in the video. This is not my narrative. This is what the video portrays. And their stated attempts to move to contact. That's what the officer stated. Those are the components that I'm getting at, that the officers are doing what they have to do to stop the threat in perpetuity, if that makes sense. It's not safe until it's safe, is really what it has to be simplified down to.
You utilize the term de-escalation. Can you explain generally what that means and how if that term found its way into your analysis?
Yeah, so de-escalation is a goal, basically. It's not necessarily a tactic. It's a composite of tactics to reach a goal of de-escalation, a goal to make a scene safe that was not safe or out of control up to that point. So oftentimes de-escalation can be misinterpreted simply because there's not a specific tactic that is called de-escalation. In this case, for instance, the suggestion for an officer to go to taser, a lower level of force to try to take custody of the suspect. Taser training states that cuffing should be done under power. Trooper North, during this event, during what I'm calling a tactical pause, says go to taser because they want to get him into custody under the power of the taser. That's a lower potential level of force to take an individual into custody to reach the goal of de-escalation.
And through your analysis, did de-escalation take place?
Attempts at de-escalation took place. And the unfortunate thing is that it takes two parties to interact successfully to reach de-escalation, meaning it takes an attempt on the officer side to de-escalate, and it takes compliance on the other side to complete that circuit to make de-escalation effective. In this case, the unfortunate thing is that the officer responded to the threatening behavior of the driver of the vehicle. And so de-escalation at a lower level of force was not reached.
Consistent with your last statement, is it fair to say that you conducted an analysis regarding Trooper North's movements and reactions on this day?
Yes.
Something that you termed a movement analysis?
Yes.
Can you please explain what that means and how it applies to this case?
It just simply, so I'm looking at what the officer stated they saw in that moment, what they believed was occurring. I review and analyze the video to see if that evidence is present. Is there actually evidence of an individual moving? And the simplicity of it is that there is evidence of the subject with a knife in his hand, I believe his right hand, turning towards the action that's happening on the right-hand side of the car, the striking of the window with the baton. He's responding with a knife in his hand. So that's part of the video analysis. And then things like shot cadence and the other audible components that we hear in the video evidence.
And through this analysis, you again analyze the materials that you were provided in 2021, correct?
Correct.
And what video evidence, if you recall, what video evidence were you sent?
It's listed in my report. I wouldn't be able to recall that.
but it was what the requesting party sent to you.
Correct. Yes. It was everything I believe that was relevant at the time.
All right. Now, through your analysis, did you also analyze what are called police tactics?
Yes, it's always a part of the analysis because decisions are driven forward by behaviors and tactics are always a part of the context. So it's always part of the analysis.
And in this particular case, what was your analysis in that regard?
Counsel, can you refine that? Because there's a lot of.
Was there an analysis of whether or not, withdrawn, did you analyze, what information did you analyze regarding policy in the Connecticut State Police regarding the way police are advised to operate?
So one of the primary components of this case is the fact that there's a pursuit and there's an end of the pursuit. And one of my opinions is about the end of the pursuit. So there's a tactic referred to as a felony car stop. So when this component comes up, I'll take a look at what a felony car stop is. And this is what I talked about, the interaction. The primary component of a felony car stop is that an individual stops of their own volition, or they're in a position that a systematic parking of vehicles, a systematic set of commands given in a specific order to protect the officers and to protect the subject. So all of those are part of training in a felony car stop. Well, if a felony car stop doesn't lay out that way, and my opinion is in this case that the way that this pursuit ended, officers had to operate outside of that parameter to try to mitigate movement of that vehicle for the safety of the public and the safety of themselves. So for instance, a policy correct felony car stop is not going to happen here. And because it didn't happen doesn't mean that the contact was out of policy. Hopefully that makes sense, and I'm not speaking in circles.
And again, in your analysis, how is it that it would be not possible to conduct a felony car stop in the traditional sense?
Primarily because the suspect didn't stop of his own volition. There was an accident, there was a collision, and the vehicle ended up stopping. So there's a difference between stopping a vehicle and a vehicle ending up stopped. Just like there's a difference between a stopped vehicle and a disabled vehicle. A vehicle that is stopped is not necessarily disabled. Those are two different terminologies that require a whole different set of analytics to confirm. Remembering that the officers are in a rapidly evolving, dynamic, tense, and uncertain situation where they're not making assessments about whether or not the vehicle is disabled or stopped. And so the concept and the tactic of moving to contact is an acceptable and viable tactic in that realm for police officers.
Earlier this morning, sir, you were speaking of a factor that goes into a certain analysis. You spoke of severity of the crime at issue. Is that one of multiple factors that go into a certain analysis?
Sure.
Can you explain a little more about that, please?
So the severity of the crime, for instance, there's a pursuit occurring. As a sergeant, a retired sergeant, if my guys got into a pursuit, this is not one of the pursuits that I would get over the air and cancel, right? This isn't, hey, my subject ran a red light and now they're running from me. And then I'm going to give them the shut it down signal. It's not that important. This particular thing with a carjacking, which the federal statute for carjacking, as citizens, we have the right to use deadly force to protect ourselves from a carjacking. That's a federal statute.
Your Honor, what the federal standard is?
This is the state. I couldn't hear you. I'm sorry.
I'm objecting to a reference to a federal standard with respect to citizens, which is irrelevant to this particular case.
Putting aside the federal standard, can you continue your response, please?
My point is that it's a violent crime. And it's a violent crime to the level that there is going to be police intervention on that severity of a crime, on a crime that's that severe.
And this factor that you're speaking of, do these factors originate from some sort of legal authority?
The three-prong test?
Correct.
Correct. Yes, that's the objective for the standard for use of force at the Supreme Court level.
Do you know the name of the case that it originates from?
Yes, that's Graham versus Connor.
So you spoke of the first factor just now. What are the other two factors?
So the next factor that's an anchor is, does the subject actually, is there an actual imminent threat caused by the subject's behavior? And in that anchor, we're looking at the pre-existing information, the fact that the vehicle has stopped after a lengthy pursuit, it's crashed into multiple vehicles. There is a family in the van ahead of them. There's people in danger. There is a verifiable, through the evidence and what we know of the case, there's a verifiable imminent threat looming in that particular circumstance.
So that's the second factor, correct?
Correct.
And what's the third factor?
Whether or not the suspect poses or is attempting to flee, avoid arrest. And in this entire case, there was never, through my analysis, let me be very cautious here, Your Honor. There's no evidence at any given time through statement-based evidence or the video evidence or any other evidence that there was ever any form of compliance from the perspective of an after-the-fact analysis on my part.
And just for clarity's sake, when you talk about there was no form of compliance as to the subject in the vehicle?
That's correct.
Now, earlier I asked you, sir, regarding what videos you analyzed and reviewed as part of your analysis. And was your response was what, that you don't recall the specific?
Yeah, I know what angles. There was a body-worn camera video from the right side of the vehicle, I believe, Trooper North's body-worn camera, and then a mobile audio video camera from a vehicle, I believe, were the three primary videos that I looked at.
And excuse me, in addition to the videos, again, other documentary evidence you had an opportunity to review, correct?
Correct. I looked at everything that was provided to me.
Can I have a moment, please?
Yes.
Yeah, I have no further questions at this time, but the Attorney General and I just approached the bench for just a moment.
Yes, sir. Counsel.
Yes.
I think I might have mentioned early on that it could happen from time to time, hopefully not too often, that we need to excuse you just for a minute to clarify a couple legal things among ourselves. And so I'm going to do that now, just for a couple minutes. So if the jury can just go into the room that's right behind here, that would be good. All right. Just be a few minutes. And I also think, Mr. Bordon, that I'm going to have you do the same thing, only you're not going to go with them. Okay, this way is good. Thank you. Okay, now I understand, Mr. Riccio, that there's something you'd like to put on the record.
Yes, Your Honor. As the court is aware, the testimony both of Professor Taylor and Mr. Bordon stated that as part of this case, they issued reports. The reports, which have not been admitted into evidence, are reports that contain factual analysis, but also contain legal opinions. Opinions about what some may call the ultimate issue in the case. That is, objective reasonableness. Was really subjective and objective reasonableness. Was what Trooper North did subjectively and objectively reasonable? And that is, as we know, the key question regarding the defense of justification. Both experts, again, created reports that in part give opinions on exactly that, whether or not they agree or disagree that there was that Trooper North acted objectively reasonable. And I have had discussions with Attorney Devlin and the court in chambers on multiple occasions about this issue of this particular opinion and whether or not this opinion can be proffered to the court and to the jury. Connecticut Rule of Evidence 7-3 states, and it's entitled Opinion on the Ultimate Issue, it states in subsection A that testimony in the form of opinion is inadmissible if it embraces an ultimate issue to be decided by the trier of fact, except that, other than as provided in subsection B, an expert witness may give an opinion that embraces an ultimate issue where the trier of fact needs expert assistance in deciding the issue. And it's that, except that portion that I think is relevant here, because what these experts are being asked to do is to provide analysis on things that the average juror doesn't possess. That's what experts do. They're asked to provide analysis and opinions based upon their specific training and experience. Now, we told the jury during voir dire, you don't need any specialized training to come and be a juror, and that's correct. And that's what experts are here to do. My point is that these experts have to date provided factual analysis, but the concern is that their report contains these legal conclusions, and I would submit that the legal conclusions regarding reasonableness and the use of deadly force in this case should be allowed under that except portion. So it's subsection A of section 7.7-3 of the Rules of Evidence. Because we know, again, the jury was told, and the court's going to tell the jury, that they can disregard or otherwise any testimony. So this is for them to determine whether or not this is valuable, whether it's probative, and whether it should be part of their analysis. I would submit that especially Mr. Bordon, who's currently on the stand, be allowed to testify as to these opinions that I've just referenced.
Mr. Devlin.
I submit, Your Honor, has ruled correctly on each of the objections the state interposed. The fundamental issue in this case is going to be whether it was required for Trooper North to fire to save an imminent threat of death or serious physical injury against Officer Rappa. That's a fundamental question, and that's a factual question that the jury is the exclusive arbiter of that to make that decision. So the opinions of these experts on that question is exactly the sort of thing that the statute or rule of evidence does not permit. This is not a case akin to a medical malpractice case, which is what is referred to on the exception, where an extremely unfamiliar, like surgery type of situation, jurors would not know what the standard of care is. But that's not the situation here. This is really a factual question that is really that jurors handle every day in our courts in self-defense cases. It just happens to be in the context of police work, which is slightly different. I understand that, but still, the way this case has come through to the jury, it really is. I mean, simply that, was this person coming through the window and needed protection or not? And that's, I think, so I would stand on the objections, and I believe Your Honor ruled correctly.
As you indicated, Mr. Riccio, would you like to respond first?
I guess I'll conclude in response to what was just stated. This jury doesn't have, other than some pieces of paper that discuss use of force matrix and policies, they don't have any descriptors of it. Again, other than the fact that it's showing up on paper, they don't know how it applies. And these experts show how it applies, or at least attempt to show how it applies. So again, I understand the exception and the specific example Attorney Devlin cites. That it makes total sense. But again, they don't know, as regular jurors or regular members of the community, specifics as to police conduct and police work, and whether or not this police officer did was right or wrong. And that is the ultimate issue, I agree. But as this section states, if it's opinions based upon knowledge that they don't have, that information can come in.
Well, I guess there is a distinction that Mr. Devlin draws between matters that are formally outside the knowledge of the run of citizens who might be jurors in a case. Anatomical information, chemical information, information about things like the tensile strength of various metals as opposed to other various metals that are simply beyond the experience of individuals, and for which they would reasonably need the assistance of learned witnesses with that knowledge. This kind of expert testimony that we have in this case presents, it seems to me anyway, a mix of that kind of scientific information with which regular jurors are not familiar, and knowledge and information and legal concepts with which the jurors either are familiar from their life experience or can become familiar sufficiently to do their job through instructions from the court, but instructions that are not on that specialized knowledge on which one of the other parties is presenting this specialized knowledge that the jurors may or may not have. I think, and it's difficult where there is a mixture of those two distinctly different matters, as there are in the testimony of both of these witnesses so far. And it's a difficult line to draw. And I think the line that has been drawn by the coincidence, really, of objections to certain of the testimony or what appeared to be imminent testimony, and the sustaining of objections is where, so far, the court has seen the line. In other words, it may be that in further proceedings, the objections will be overruled or sustained. I don't know, because as we indicated when we spoke off the record, it seems like we need to do this on a question-by-question basis because of that mixture that is really part and parcel of the expert testimony, it seems to me, in this case. I mean, I think that, for example, when Mr. Taylor was explaining to the jurors about reaction times based on his experiments, and then reaction times that actually occurred based on the evidence in this case, measurable reaction times, and for those to be compared, and for there to be an observation that, for example, and I don't know that this actually happened, but the reaction time of somebody on one of the body cameras was within the range of reaction times in an experiment that, say, Mr. Taylor had, or Dr. Taylor, I guess, had run. That might be useful for the jury to understand where a particular reaction falls in the range of reactions that Taylor was able to observe in this run of experimental subjects. And that seems to me, would be useful for the jury. They don't have that information, and it is, I think, could be relevant, and I think permissible under Rule 7. But I think for then Mr. Taylor to go on and say, and so that was unreasonable. That part of it, I think, is for the jury only, and I think that's within their ability and within the parameters of the task that the law leaves to them. And I think some of the objections that have been interposed and sustained have been situations where my perception was that the testimony or anticipated testimony was more on the latter side and less on the former side of the sort of dichotomy that I just explained. I think, your objection is well taken. This is an objection, right? The whole correct thing is well taken. But I think that I'm inclined to, and I will stand by the rulings that I've made so far, and will suggest that we're probably going to need to keep doing it this way, because I think we're going to see from at least from Mr. Bordon, material that, in my view, is admissible. It's on the admissible side of a sort of red line that Rule 7 draws, and some is going to be on the other side of the line. So I'm going to propose that we continue to do it the way we're doing. I think you needed to make a record, and I think you have, in my view, made a record of this objection, which I consider to be entirely appropriate. This is just a difficult area, I think. So I think, have we accomplished your purpose?
Yeah, sure. I just wanted the record to reflect that the inquiry would have gone farther had those questions been posed, but this colloquy dealt with the restrictions, or my argument that there isn't a restriction that Rule 7 provides, but the court has enunciated its decision.
Yeah, I mean, I don't mean to constrict unnecessarily the questions that you choose to ask. So to the extent that the rulings of the court, the objections of the prosecution and the rulings of the court have done that, they've done that because it appeared that where the objection was interposed was the beginning of territory on the far side of that red line. And, I would encourage you to continue to prod and test with your questions where that line lies in places in the testimony where you feel that it's important or even necessary to do that. Because until the things happen, until we hear the phraseology, until we hear what the witness appears to be about to go into, I don't think we can really tell. As you said to one of the witnesses, the reports, or maybe to the court, the reports of each of the gentlemen who were called today, and this is not saying anything negative about them, it's the nature of their business. Some of it is admissible and some of it isn't, I suppose. Anything else?
Finally, without belaboring the point, again, there are certain exhibits, for example, like the use of force matrix. I keep going back to that I don't know how the jury knows how to apply it or interpret it or use it. So again, people like these gentlemen could provide such an explanation. And in so doing, again, it depends on the questions that are being asked, but those are the areas that, again, I think the typical juror does not have common knowledge of.
Yeah, I mean, that might be true. And in some instances, like just the example that I used from Dr. Taylor's testimony, which was half made up, but I think the point got across. I think there are definitely going to be areas in this kind of testimony that the jury does need assistance with, but there are going to be others that have more to do with the assessment of what happened as disclosed by the evidence as processed by reasonable citizens of the Republic, like our jurors, is going to be what we need to get to ultimately. And we can lose that if their perceptions are overcome by pronouncements of experts, which invade their province. So,
Thank you.
okay. Anything else before we bring the jury?
Just one quick, one final question. I will retrieve the witness. May I did state that I had no further questions. May I reopen my questioning based upon the court's rulings, just ask a couple additional questions?
Do you have any objection, Mr. Devlin? You may.
Thank you.
So you want to bring the jury and bring the witness.
Thank you.
Please. 6 jurors, 2 alternates, right, gentlemen?
Stipulated to this as to the present, Your Honor.
Stipulate.
Thank you. May inquire, Mr.
Thank you.
Riccio.
And before I ask the question, you can have a seat, sir. May I approach the clerk for just a moment?
Yes.
Mr. Bordon, good afternoon now. Just a few last questions, please, sir. As part of your analysis and investigation into this case, were you provided or did you look at the state of Connecticut use of force matrix?
Yes, it's actually in my report.
Okay. And Your Honor, may I approach, please?
Yes.
I'm going to show you what's been marked as States 41. And it's a full exhibit at this point. Can you first hold it up to show the jury sort of the colorful nature of it? And then if you could describe it and how it's put into practice.
So it's sectionalized, and this would be considered some sort of a continuum, if you will. So it shows in the red areas what would be considered non-compliant, the green area is compliant, and then it's got an associated terminology with that. And then it refers to probable ineffective control, probable effective control, and probable excessive control. It has a decision-making process here that is identified in a loop fashion, which in most of these is identifying a point where there's time to analyze, assess, and make optimal decisions. That decision loop becomes a loop. There's a place for that in the decision-making process. Sometimes it doesn't exist. And basically that's how this is laid out.
And you testified that you looked at this in this matter, in the Trooper North matter, correct?
Correct. And so what I looked at primarily and what's in my report is the underlying use of force matrix, which is on the next page as part of it. And I've used this as the third anchor associated with the objective standard that we talked about, and then the Connecticut general statute.
Now, you just made reference to Stage 41 and the last page, which has a lot of writing on it. What particular sections of that page did you find most relevant to your analysis?
So in this matrix, I read through each one and I identified that in my report, I've highlighted the sections that had the most attachment, if you will, congruency with this particular incident. Would you like me to read?
Please read those sections that you believe are most relevant to this analysis in this case.
Do we have a copy of my report where they're highlighted? Otherwise, I'm going to read the whole thing.
I'll ask you just to refer to the document that's in evidence right now, if you would.
Good enough.
You just read whatever you thought were most relevant to your analysis.
Okay. So one, all legitimate uses of force in law enforcement or custodial setting are ultimately justified by an articulable need to exert some level of control over another person. So in that, I'm looking for the articulable need to exert some level of control. That's an important component. That's where the investigative analysis comes in. What was the articulable need? What did the officer state? What's the evidence? What does the video show? It is the subject's actions which dictate the quantity of force used by an officer in response thereto in order to exert control, meaning that is the officer proactive or responsive? And in these types of cases, I'm looking for the articulated statements, the stated beliefs of the officer, and how that attached to this, the subject's actions. No action was taken until there was a subject action that the officer was responsive to in that moment. The need to exert control over another person in a law enforcement or custodial setting in a rapid and unpredictable environment. So, and their ability to continually assess in that, and that plays a very important role in this particular case. This is rapidly evolving. There's very small increments of time or windows of time to make a decision to protect oneself or to protect others. The timeliness in which it is applied is important. What is that window of time based on the articulated threat supported by the evidence? The decision to use force in a tactical environment is not progressive in nature. Rather, the use of force focuses on, Your Honor, can I read from this? It says reasonableness. I want to be careful with that term.
If someone objects or I instruct you,
Okay.
continue reading.
The inquiry focuses on the reasonableness of the force options actually employed. That's what the document states. The use of force, let me back up to that. So in the analysis, is there deadly force was used? We start there. Is there a sustainable cause and an articulated belief that deadly force was necessary? The use of force inquiry focuses not on what the most prudent course of action may have been. It's a range of conduct. This is the objective standard, meaning that because one decision was made and another decision could have been made, it doesn't necessarily make the one that was made inappropriate. And that's an important component in the objective standard, meaning that there's no legal requirement to choose one correct behavior because we're making decisions in rapid fashion, in a split second, facing a responsive action. The officers are responsive to an immediate threat. That's what that section means to me. So to summarize that, it's whether it was a reasonable response, not necessarily a perfectly correct response. An officer has to be reasonable, not right. And that's an important component. The officer's perceptions under number 7, the appropriateness of a force decision is judged on the basis of the reasonable officer's perception, not talking about the reasonable force, but the reasonableness of what the officer perceived. Did what the officer stated they saw, is it supported and substantiated by the evidence in the case? The appropriateness of a decision to employ a particular tool. There's a deadly force threat. Is the officer responding with the appropriate tool for a deadly force encounter? The degree of control which is likely to result based on all of the circumstances, not known in hindsight, but known to the officer in the moment. That's an important component. It's totality of facts and circumstances that the officer perceived and believed in the moment. The degree of force which can be appropriately used to respond to a threat increases proportionally in relation to the degree of that threat perceived by an officer to the immediacy of the response required. Is it rapidly evolving? And is there evidence of that? The reversibility of a decision to use force is inversely proportional, meaning was there a change in behavior and did the level of force that was used to gain control stop immediately when there was a change in behavior? The greater degree of force employed, the more likely it is that physical injury will result. The resulting physical injury will be serious in nature. The greater the probability of injury to a subject, the greater the potential for liability to the officer, as we're talking about in this case, the greater the advantage for the officer needs to be. The officer is placing themselves in a position of advantage over a potential or a perceived deadly threat.
Thank you, sir. One more moment, please.
Yes, sir.
Just one more very slight area. I have that back. Sorry. I should have handed it back. Thank you.
You took the risk.
I took the risk tonight. Okay. If I could return 41 to you, sir, getting back to the use of force matrix, that colorful series of boxes there. Through your analysis, can you determine, again, from your factual analysis, where Trooper North fit in that matrix?
I'm object to that.
I'm not
We
sure.
can talk about the matrix and what it sort of indicates there. Actually, the jury can read the document. He just read the document to the jury.
I understand. Can you?
I'm objecting to
sustain
that question.
I'm sustaining the objection.
Yes.
Can you ask another question?
Yes, I shall. Sir, you just discussed and read the final page of this document. Is there a colorful matrix that is also on this document?
Yes.
And can you do, I think you already did, but can you describe how the matrix operates and then how it applies to this case?
You already described how it operates.
Okay.
Describe it.
Well, there may be more to it. That part of it, I think I'll allow. The other part of it, though, about where the defendant falls on it, I think will lead to the jury.
And I know the witness has already described the operability of the matrix.
I think he has.
Well, in that case, sir, then I have no other questions for you. Thank you very much. I'll retrieve the document.
Thank you, counsel.
May I proceed, Your Honor?
Yes.
Okay, thank you. Just a few questions, sir. You acknowledge that the officers did not employ classic felony stop procedures in connection with this case, correct?
Counsel, can you speak up? I'm sorry.
You acknowledged on your direct examination that the officers here did not employ classic felony stop procedures in connection with this case.
Correct. I stated that it was not suitable for classic felony stop.
And that was principally because the vehicle or the operator did not stop of his own volition, correct?
That's correct.
But the vehicle was still stopped, correct?
Correct. From what the evidence in the case shows, the vehicle was stopped. We can see that in the video. However, the vehicle was still in gear, I believe.
Do you know that?
Yes, it was in the statements.
Okay, well, the jury will decide that. And the objective here is to get the operator out of the vehicle safely, correct?
The objective of the police officers?
Well, the objective of the stop, the objective of the police officers is to, I guess, make an arrest to get the person out of the vehicle safely to make that arrest, correct?
Correct. In this environment, and I appreciate that statement. I know what you're saying. Yes, the goal of the police officers is to move to contact, understanding that there is a danger. Police work is inherently dangerous, is to move to contact and remove the threat from a position of being able to continue threatening behavior.
And approaching the vehicle, sir.
I'm sorry.
The vehicle, you finished the answer, sir. Approaching the vehicle is extremely dangerous for the officers, isn't it?
Yes, it is.
Right. And in this particular case, as you recall, there was basically no communication with the operator of this vehicle, correct?
No established communication, correct.
Correct. And the officers, I mean, you use this term de-escalation to mean, de-escalation means ending the threat. Is that how you interpret that?
No, sir.
Okay. Well, you indicated that moving to contact was a form of de-escalation.
You're mincing my terms. Your Honor, would you like me to re-explain what I said?
No, I'll ask the question, sir.
Okay.
Okay. And so, well, de-escalation, doesn't that mean sort of reducing the intensity of the event?
That's not incumbent, and that's a great question too. De-escalation, again, is not a tactic. There's no magical tool that we can wave over a scenario to create a de-escalated or safer scenario. De-escalation, again, is incumbent on the involvement of the suspect and the compliance of the suspect to collectively de-escalate the scene. The officers, again, are responsive to the behavior of the suspect. If the suspect doesn't comply or associate themselves with de-escalation, then de-escalation hasn't been met.
Well,
And
what efforts at
I'm still
de-escalation was
speaking,
made?
counsel.
What efforts at de-escalation were made here, sir? What efforts at de-escalation were made here, sir?
Okay, I'm gonna try to answer fully to you. The efforts to de-escalate is simply trying to use a lower level of force than deadly force to get what is potentially a deadly subject out of a vehicle. At the moment that Officer North tells Trooper Johnson to go to taser, that is trying to develop a plan to de-escalate with a lower level of force, to cuff under power in that scenario where it's rapidly evolving, unpredictable. They can't predict what the suspect is going to do. And that is considered a form of or an attempt to de-escalate with a lower level of force.
I know further questions.
I have no other questions. Thank you.
Okay, all right, thank you, sir. Thank you very much.
Thank you, Your Honor.
You are excused.
Thank you, ladies and gentlemen.
Mayor, at this time, the defense rests.
Thank you, Mr. Riccio.
We have one rebuttal witness, Your Honor, that will be available tomorrow morning at 10 o'clock.
Okay. In that case, I think we've done all that we can do today. In fairness to the parties, it is the case that some of the witnesses toward the end here have had traveling issues. So they've been sort of spread out. Yesterday, as you will recall, we had one witness. Anyway, we've had all the witnesses we're going to have today. So we're going to end early today. And I expect that tomorrow will be the last day of evidence, and we'll see what we can get done. In the meantime, don't make up your mind or form any opinions about the evidence that you've heard so far. Do not discuss with anyone, including your fellow jurors, the case. Do not seek out any information from outside the courtroom in any manner. Do not do any site visiting or investigation of your own. Do not answer press queries. Do not watch anything on any media that appears to you to have to do with this particular proceeding or the underlying facts or anything that's like this. We will all see you in the morning. Okay. And so tomorrow, Mr. Devlin, do you expect that your witness is going to take the entire day?
No.
I just want to get an idea of what else we might accomplish before.
I'll say we'll be done in the morning session of court.
In that case, I think you guys should be prepared to sum up.
All right?
That's fine.
And I'd like to get us into a position where we're prepared, or where the court's prepared to instruct the jury as well. Because if it's early enough, we'll see. But if it's early enough, I'd like to try to do that if we can and get them with the case.
Tomorrow as well, if possible.
If possible, yeah. And in that regard, are you gentlemen available for a few minutes to talk about the charge on a record?
Yes, sure.
Yes.
You want to just do that now, or do you want to come back after lunch? What's good for you guys?
I'd rather come back after lunch because you want to read one case in connection with this sort of central issue, which statute we're going to use in terms of the use
That
of
would
force.
be good. That would be good.
Okay, so if we can have till 2 o'clock.
Okay, you want,
That's fine too. There is, I think we're really only quarreling over one particular charge.
I don't see us as quarreling, actually. Maybe we'll quarrel this afternoon. But that would be, so I want to come back at 2?
Yes.
Yes, thank you.
Okay, all right, we're in recess till 2. Thank you.
All right. Court is again in session. You may be seated. Good afternoon, Your Honor.
Good afternoon, Marshall. Good afternoon, everyone. Thank you for coming. Just wanted to talk a little bit about the charge. Mostly it's going to be about the crime and the lessers and the defense. So I had given you a copy of what I had up till whenever it was I gave it to you guys. Did you get a chance to look at it?
Yes, I did.
Okay. Any kind of gross objections? It kind of tapers off at the end into like a document that doesn't really isn't formatted. But
Well, before we get to, I guess, the heart of the matter, which is how we instructed the crimes, a couple little things I would point out to the court. These are minor things, but for example, at the bottom of page 14 in your chart, in the draft you gave us.
Yep.
14 on top of 50, that seems to go to identification evidence, which is really not really in play in this case. I don't think that's necessary. That last sentence touches other factors you may consider through to under which a witness observed the person. I just don't see that as really necessary in this case.
Do you agree, Mr. Riccio?
I would agree. This is not it's not an identification case, so that's
Right. Okay.
And on page 19, I would suggest a list of experts would be Douglas Lacey, Lisa Ragazza, Jacqueline Nunez, James Bordon, Paul Taylor, and assuming the court finds the qualifications of Mr. Porcher acceptable, Darren Porcher.
Who was the person that you named after Lacey?
Lisa Ragazza, the firearms expert from the State Crime Lab,
Right.
and then Jacqueline Nunez from the medical examiner's office.
Okay. 1, 2, 3. Okay. Any other ones?
So six in total. Lacey, Ragazza, Nunez, Taylor, Borden, Porcher.
In case I haven't written them down, Lacey's first name, I'm sorry.
Douglas Lacey, Lisa Ragazza,
Alyssa?
Lisa, Lisa,
Sorry. Yes.
Jacqueline Nunez,
Yeah,
James Borden, Paul Taylor,
I have those.
and Darren, Darrin, Porcher.
Okay. Beyond those, Mr. Devlin?
Only, I would just like to be heard on the manslaughter one instruction, and particularly the instruction regarding the justification language.
Okay. So I'll hear from Mr. Devlin. If you want to, is there anything else that you have, Mr.
We can get to that. I think what we also had discussed was we don't think that any interrogatories are needed.
Yeah, I'd like to talk to you about that too. That was just amusing, me thinking
Okay.
out loud on paper. Okay, so then,
So I think the instruction on man one with a firearm is fine. I think it's an accurate description of the elements of that crime. So I'm just going to focus on starting on page 34, where you talk about the defense.
okay, that's right out of the book, basically.
Right.
You were going to pull what out? I'm sorry.
Well, I'd like to, my bottom line on this is that the instruction that you have here is accurate with one change. And that is when you talk about the objective
Yes.
test, it should be
Reasonable.
a peace officer, not reasonable person.
Right, I did read Smith, so. yes.
So, but I think Smith, and then the commentary to the instruction that Attorney Riccio put forward, section 2.8-6, which talks about 53A-22, they come to the point where if it's a deadly force situation, then the objective subjective test in State against Smith, as represented statutorily by 53A-19, should be used with it being described as tested against a reasonable peace officer. So these two statutes, 53-22, which talks about force using in connection with an arrest, and 53-19, which talks generally about use of force, defense of persons, they kind of merge a little bit in this particular case because it has elements of both. But what I don't think the pattern instruction addresses is the language of 53-22C, which talks about the, when deadly force is used, it has to defend self or third person. So I think your instruction is fine with that modification I mentioned.
Does it, so, but can you be more specific about C in 53A22 that you don't?
I don't think that the pattern jury instruction that in the pattern instruction book of 2.H-6 addresses the language in 53-22C, which talks about the use of deadly force. I just don't think this instruction speaks to that, which is central to this case.
Well, I guess in that regard, I mean, because I think that Mr. Riccio has actually requested that as the charge for the defense.
Right.
I guess a lot of the evidence did seem to me to have to do with defense of another. Both on direct and on cross of the defendant. What do you? So are you? That's your. Is that your defense?
Well, the defense is defense of others, obviously. But the reason I believe that the defense request charge, which was a request for 2.8-6, why I believe it applies over the other, which is the 53A19. First of all, the law is in this area is 53A22C. I think we can all agree on that. But if you look at the commentary before the actual jury instruction begins, it explicitly states, no, this defense applies when a peace officer has been charged with an offense arising out of the alleged use of excessive force, and this instruction is written for that situation. It also talks about the statute comes into play when someone's charged with interfering or assault on public safety. The next paragraph explicitly states, this statute also applies when a peace officer is claiming self-defense charges arising out of an incident when the officer was attempting to make an arrest to prevent an escape. In that case, the self-defense instruction as written for 53A19 may be used, changing reasonable person to reasonable peace officer. My point is it explicitly states that for a situation that this case is about, this instruction is written for that situation. I think that this does talk about deadly physical force. It's the second page of the pattern instruction, so I don't know how it corresponds to my filing, but there's a heading of deadly and non-deadly physical force, defines what it is. It then goes on to talk about the subjective and objective analysis, which again, I know the state's not contesting that that's the analysis this jury has to undergo. 5322C has been tailored for this ideal situation. I understand we can tinker with the language in the 19 instruction, but this is tailor-made already for this. It talks about deadly physical force, the objective and subjective analysis that has to take place. That's why I think that this is perfectly applicable here.
I don't see any place in this proposed instruction that the defense has put forward that you can only use deadly force to defend yourself or a third person from deadly force. I don't see that language anywhere in here, which is a central point of the whole thing. I mean, you can use deadly force to defend yourself against deadly force or a third party against deadly force or serious bodily harm. I don't. Can you, if Mr. Rick can point that out to me, I'd be happy to look at it. I can't find that.
Well, I think that the pattern instruction, I think, does.
Yes, it does. That's why I have no objection to it.
No, I mean, the pattern instruction from 53A22.
Well, let's see.
I think I left it in my office, but I think so.
Honestly, I don't see it, Your Honor. I don't see it in instruction 2.8-6. I don't see it.
And just, I understand what we're quarreling over. We're quarreling over, and Attorney Devlin, correct me if I'm wrong, this case is about defense of others. At least that's the defense, is that he acted in defense of others. And I think what the state is saying is this instruction talks about using force and either making an arrest or preventing an escape. Is that a fair assessment?
Yes, and this instruction doesn't address subsection C of the statute 53-22, which talks about using deadly force.
To defend
Yourself.
a third party.
Yeah, third party.
So in that regard, I agree, because, again, to make sure the record is correct, 2.8-6
That's
makes reference to, in its title, 53A-22C.
yes.
But in the body of it, it talks about making arrests or preventing an escape. And I agree, this is not that case specifically. This case is defense of others. I mean, arguably,
Right.
we know where I'm going with that. But the point is, this is a defense of others case. So, but then 53A-19 doesn't accurately state what 53A-22 is supposed to say. To Attorney Devlin's point, which is it mentions defense of others, but then does it accurately, because it has the subjective and objective analysis, which again is the analysis the court has to undergo. It just, I guess, 53A-19 seems a little confusing. It does include defense of others, which is what this case is about.
Yeah, it is. That's what it's about.
Correct.
And it also, I think, posits in subsection B, right? Or if he or she is a peace officer. So it does contemplate 19 being used in a situation exactly like this with a peace officer and all. You know.
I guess one of the concerns too was, and this is the risk of looking at pattern instruction sometimes, is you see all these other terms that could be used. And, I first looked at 53A-19, they're talking about whether it's duty to retreat or mutual combat. Obviously, this case is not that. It just seems like it was overly complex. Now, I understand cut and paste what the applicable sections are. Look, as long as the instruction includes defense of others, which 19 does, but also has the subjective, objective descriptors that exist in the 22, which is 2.8-6, I would be fine with it. I think that both the 19 and the 22 jury instructions have that subjective, objective description in it. I just seem to like the language of 22 a little bit more.
Well, I think 19 is, it seems complicated to me also, but I think it's got everything in it that we need. I also, as I said, I have some concern about, you seem to be under within subsection C of 22, you seem to fall under subsection 1, which is defense of others.
Right.
Or you could fall under 2, but maybe not, because you might not fall under 2.
And I don't have it in front of me. What's 2?
2 is effecting an arrest or preventing an escape. And the preventing the arrest has to do with a crime that you may not have here. So that
Well, I guess that's subject to argument too, because it's a crime that I think we've learned through the evidence may not have happened, but this case is about what the officer thought he believed, right?
But he would have to believe that it was a crime where there's a threat or an infliction of serious physical injury, and carjacking is not such a crime.
Well, I know we had this discussion in the
Right.
chamber. I guess without going down that rabbit hole.
Well, I don't want to go down
Right.
that rabbit hole. That's the idea.
Right. So I think defense of others, that's what this case is about. There's no need to pivot because the evidence is about to be closed. So defense of others is this case. That's what the jury should be instructed on.
I would just direct the court's attention to State against Smith. The only case we have that is considered this question. And at page 205, we're at the conclusion of the court's opinion written by Judge Schaller. And I'll just read this. As discussed in part 2, the test for determining whether a police officer's use of deadly force was reasonable is to be judged according to the subjective, objective formulation used in evaluating self-defense claims under 53-19. With respect to the objective part of the test, however, the reasonableness is to be judged from the perspective of a reasonable police officer. And here the court refused to do so instruct, and therefore they reversed it and remanded it for a new trial. So what you've done here, Your Honor, in your proposed instruction is exactly that. You've taken 19, and we're going to modify it to change the objective part of it to read peace officer. I think that's an accurate statement of law, and it perfectly explains it to the jury.
Okay. Well, I think, and I don't hear a strenuous objection anyway from Mr. Riccio.
I don't. Again, I understand 22 is more of the subsection 2 affecting an arrest or preventing an escape. It's misleading. I know we all agree that the jury instructions as drafted are not perfect. In fact, they're behind the times because of what happened in 2021 with police accountability. But point is that they're not perfect. I think I'm not strenuously objecting because 19 does also correctly state the law. I will look at it one more time, but I don't have any strenuous objections.
Okay. And then on the defense, because of the interplay between the defense and the lesser included offenses. Anything on the lesser included offenses? Those are right out of the book too.
Yeah, if we could just go back to the defense or general defense first. I mean, as I see it on page 38 of your proposed instructions, Your Honor, about halfway down the second paragraph where you see in this, it reads, the second question you must ask is whether the actual belief was reasonable in the sense that a reasonable person would actually be
Peace officer.
Yeah, so,
and then there's about 5 lines down further.
Exactly.
It's just got to be going through. And,
Okay, good. Okay, that's all I'm good. So on 38, I see that, and I see it also on page 41 and page 42.
41 and about the 4th or 5th line down.
Yeah.
Yep. And then
42 about 5 lines down.
Yeah, about 5 lines down. Yep. For sure. And I was thinking that maybe if you think, having read it freshly, that we could get away with it, I prefer not to use like a verdict form. How do you feel about that?
The state is fine with an oral verdict by the jury subject in response to the inquiries by the clerk. To, man, one with a firearm, guilty, not guilty. And then if they find that the person not guilty of that, then you proceed that first lesser included offense, guilty, not guilty, second lesser included offense, guilty, not guilty, and then that's it. I know Attorney Riccio was thinking about maybe a written verdict form. I'm happy to look at that, but the state's preference would be just a regular general verdict that we have in these cases regularly.
That'd be my preference too, generally, but I just wondered whether or not it might be important for them to have some instruction about what order to do these things in.
Well, and that's where I was going with my request for a written verdict form. I trust that they'll do their duty and follow the court's instructions. It's not just simply a 1-count information and then that's the end of the analysis. It's I think that it has to be written out that if you find him not guilty of this, go on to question 2. If you find, if you find him guilty, then you don't have to move on to question 2.
Right, and that was the purpose of the sort of halfway completed interrogatory that's on the back of, or that's around page 44 or 6 or something, which would basically lead them through it. And then there's a couple of conclusions that would be there too, because I didn't finish doing the thing. But the idea would be that sort of, you would answer the questions in the order in which you'd want the things to be considered, and that would lead you all the way through it. But that can be done in text as well.
Right.
And so I would be happy to do that.
I would suggest, Your Honor, that at page 28 of your instructions, where you introduce the concept of lesser included offenses, there should be a discussion of the acquittal first rule. In other words, if they don't move to a lesser included offense unless they unanimously find the person's not guilty of the greater offense.
Yeah. There should be. I thought I had something about that. Well, so, and I think that I also think that on page 28, where we begin to first talk about the lesser included offenses, what I wrote is not a good idea. That is, if you unanimously find that the state has proved beyond a reasonable doubt each of the elements of the crime of manslaughter in the first degree with a firearm, then you shall find the defendant guilty. It would probably be clearer if it went right to, if instead of mentioning guilt, if I just leave it at the elements, he found the elements beyond a reasonable doubt, all of those elements.
Well, I would suggest that if in that sentence where it says,
then you should go on.
It would say you shall go on to consider the defense of others.
Defense, yeah.
Right.
And then on the other hand, if you've acquitted on that first, then you shall consider the lesser included offense.
Right, that's the right statement on the law. If you, on the other hand, if you unanimously found the defendant not guilty of the crime of manslaughter in the first degree with a firearm, you shall then consider the lesser included offense.
Do not consider the lesser offense unless and until you have unanimously acquitted the defendant of the greater offense.
Correct.
Right? Does that work for you, Mr. Devlin?
Yeah, so basically, you would, in the first sentence, you would end it with guilty, but you would direct the jury to consider the defense of others.
That's something I wanted to ask about, because some of the papers that are in the jury instructions make it seem as though you would let them find the defendant guilty before considering the defense, because it is a defense after all. So it makes sense to me that way. But I had thought in the first place, and then I changed it back, to just refer to it as having found all of the elements of manslaughter 1 by beyond a reasonable doubt, and not mentioning a finding of guilty, and then having them go look at the defense.
To me, I think finding of guilty means elements proven beyond a reasonable doubt and justification disproven beyond a reasonable doubt. Both of those things, that's where you get to guilty.
Right. So there shouldn't be reference to a finding of guilt until the defense is considered. Yeah. Okay. So then it's just going to say the elements. Right. And given that, though, that paragraph makes sense to both of you?
Yes. It just, right, because to say then you shall find the defendant guilty, so if it closes the analysis, I think it's correct to saying if you find that the state proved each of the elements of the crime, then you move on to the defense. And then I guess it should say, if you believe the state has, hold on. If you believe that the state has failed to disprove beyond a reasonable doubt the defense, then you have to find him not guilty. On the other hand,
it says that when you get to the defense.
Okay.
I
just want to make sure that the map we're providing them is correct, because
no, you're right, and I'll definitely run through it myself as well, so I end up in the right place. But I think the way that the format of this is that it goes through the offenses first, all of them, and guides where you have to get off of that train, it guides you to go to the defense.
Okay.
And then in the defense,
States that.
yeah. And it indicates that it can apply to any one of those three charges
Right.
that get you here.
Correct. Yep.
By saying, if you find that the state has proven beyond a reasonable doubt each element of one of these three offenses, you must go on to consider whether or not the defendant acted in the defense of others.
What page are you on?
That would be 34
Right. Okay.
toward the bottom.
Right. Yes.
And then it would just go through the defense with the changes that Mr. Devlin pointed out. Any charges that either of you beyond what you've requested already that you want to have in here?
Not from the state.
No, you're right.
Okay. Anything else on this?
Well, what, has Your Honor resolved the question of verdict form versus no verdict form?
Yeah, I think that was my intention just now, I think I can just do it verbally the way that we just talked about,
I'm fine with that.
and that'll be sufficient to get them to where they need to be. Does that make sense?
Either that or my alternate recommendation is to take what's on page 45,
That's the,
the verdict, the interrogatory as it's defined in this draft, change the term interrogatory and have it say verdict form, and then the rest of it just remains. Because the rest of it, as charged manslaughter in the first degree, we find the defendant guilty or not guilty. If not guilty, go to 2. If guilty, go to 4. I mean, that follows a typical verdict form, if you will. I think that if we keep this, we just call it verdict form, that would work.
How about number 4?
well, it would be, no, there's a little more. So what it would say, instead of guilty, it would say elements are satisfied or whatever, like we did in the text of the instruction. And then at the end, it would say something, a reference to, we find that they find the defense or don't find the defense. And then as to each of the crimes, or as to one of the crimes, whichever one they found him guilty on, if they got to this, if they didn't get to it, obviously not guilty. If they did get to it, then it would say they would check off which one they found the elements of, and then the result from the defense.
I would object to that. That seems to be overly confusing. And the language here, no elements disproven, the double negative in there.
Yeah.
I think that's very confusing to the jury.
It is. I think that.
First of all, the state's preference is just for a standard general verdict report by the jury. If Your Honor is going to go here, I would say superior language would be something like defense of others disproven, yes or no, something like that. So it's not, we can do it that way, but I would prefer just a general verdict. No need for interrogatories. It's a one count information. So that's the state's position.
Yeah, it was only because of the lessers and the defense that I thought maybe that. I mean, I saw some documents that had arrows all over them and stuff, and just really complicated directions for something that isn't really that complicated. It's just complicated if you try to say it and make it linear. But I think that it comes out of what we just had come to fairly clearly. So I'm inclined to not use the form. I mean, not the form I have for sure, because it raises some of the issues that we've already resolved in the text.
So if we do it that way, again, we're still getting the responses from the jury, their verdict.
Because the clerk will ask the questions.
Right, but if we can resolve the issue where Attorney Devlin is correct as to number 4, do we even ask them as to defense of others, has it been proven or disproven? I mean, the verdict should presuppose that they've done that analysis. So I don't know if we need to ask them specifically as to the defense of others.
Wait, I don't know if I follow that.
Sure. So
You're saying eliminate this?
correct.
Okay.
That we were just talking about how we were looking at the language, and to find a defendant guilty or not guilty, they have to first look at the elements of the offense and then 2, shift to the defense to see if it was disproven. I think 1, 2, and 3, whether it's written or oral, is fine. I don't know if we have to then ask them in essentially in the form of an interrogatory as to the defense, has it been proven or disproven? Because that's in sort of inartful language. That's what's here on page 46 of the proposal. I mean, this language isn't good, but even if we dressed it up, I don't even know if it's necessary.
So we would find out the result.
Through their verdict. I mean, I suppose I could sleep on it and let you know in the morning because it'd be easy to add if necessary, but I just think it should be clean as to the charges, guilty or not guilty. Again, assuming that if they find a defendant guilty or not guilty, they've done the analysis of elements of the offense, then the justification or defense of others defense.
Right, but if they just said guilty or not guilty, we could assume that they did that. I guess that's what you're saying.
Right. I mean, again, I don't think this is something that has a huge effect. I mean, it's a simple question. As the defense of others, was it proven or disproven? Or, as the defense of others, was it proven beyond a reasonable doubt or disproven beyond a reasonable doubt? Or actually, was it disproven beyond a reasonable doubt, yes or no? That's the language. That's what it should say. If it's going to say, or if our clerk's going to speak this, it should say, as to the defense of others, has the state disproven the defense beyond a reasonable doubt, yes or no? I suppose that's an interrogatory.
It is not.
Which, again, I think now we're going somewhere we don't want to go.
On a general verdict, the jury is presumed to follow the court's instructions. You're going to tell them to find the defendant guilty of this charge. They have to find the elements and self-defense, defense disproven. I think, to me, that's totally sufficient in a case like this.
Okay. Well, I like that. I mean, I prefer not to introduce more difficulties into the situation and potential difficulties.
Great.
So, okay, so that's what I'm going to do, okay?
Okay.
Anything else?
Counsel instruction. No objection to the rest of the instruction.
No objection to the rest of the
Thank you so much. And so I think we're all set until tomorrow. And I'll make the changes we talked about. I'll send a copy out to you guys today, and then you'll have it. And that's it.
Thank you.
So 9 to 10 tomorrow, somewhere in there. We're going to start at 10.
10, okay.
Okay.
All rise.